Today I want to talk about domestic violence and parenting time issues. And the reason why I want to talk about that is because I am a criminal defense attorney and I also handle domestic law. And because of that, these types of cases sort of often end up in my lap where there's been either an allegation of domestic violence and the person is seeking parenting time, or the person has been a victim of domestic violence and they are trying to restrict parenting time. And it's critical, if you're in either one of those situations, that you understand the law on this. And the statute that I'm looking at is 25-40303. And in fact, I have it here in front of me, and I would encourage any of you who is listening to this that you go and look at the statute because it's pretty complex. And I just want to kind of hit on a couple of the points. The first point is that if there has been, and it's significant is the word, and by that the court, so it's not going to consider, like, say, if there was a minor act of disorderly conduct or something like that, a misdemeanor, that's probably not going to be given a lot of weight. But it's required to look to see if there was a significant act of domestic violence. And if it makes that finding, then the court is required to make additional findings about legal decision making and parenting time. And it's that, for one, legal decision making would not get awarded to the parent that is the guilty party of the domestic violence. And parenting time, and we're in a state that is an equal state as far as parenting time, the court is required to actually try to maximize parenting time for both parents. If they make findings that there's been domestic violence, that can absolutely heavily impact your parenting time. The other part about this is something called a rebuttal presumption. So if you've been found to be the person that committed the act of domestic violence, you're not totally hosed. There are things you can do to try to fix that. And basically what the court can do is that they can make this finding, but they can look at all the steps that you've taken to try to remedy it. And for that, that means classes you've taken, counseling you've undergone, if there's a substance abuse issue, things that you've done to address the domestic violence. So to sum it up, the main thing for you to understand is that if there is a domestic violence issue in a family, it is critical that you come prepared to talk about that and to address it, because it's going to impact your case. Number two is that you have to be willing to take steps to deal with the domestic violence. And number three is that if you are trying to show that the person committed significant domestic violence, then you need to be prepared to come with the kind of evidence to prove that these types of things were happening in your household prior to you wanting to get custody orders. I'm glad you've taken the time to listen to what I wanted to talk about today, and I really think it's important to read the statute. Please feel free to call my office and set up a free consult, and I will talk to you about domestic violence and parenting time. Thank you.